Now, back to On the Market on 105.9 The Region.
You're listening to 105.9 The Region, and welcome back to On the Market, York Region's only radio real estate show. I'm station manager Tina Cortez, and my co-host is Asif Khan with RE/MAX Prime Properties.
Thank you, Tina. Joining us next is one of our regulars, real estate lawyer and broker owner from RE/MAX Empire, Ricky Rathore. Ricky, welcome back.
Hey, thanks, guys. Thank you for having me.
Ricky, it's that time of year, July 1st long weekend, and a lot of houses closed this weekend or yesterday. We usually get a lot of calls from frantic buyers that have moved in or gotten the keys and they've found some defects or they've found something missing. What's your weekend going to be like?
So, guys, it really comes down to the contract, and I can't emphasize this enough, and it's so important. And when you're signing off on an agreement of purchase and sale, that you've gone through that document very carefully, line by line, literally, with your realtor to make sure you understand what you're signing up for. Because more often than not, my authority as an attorney to act on your behalf flows from that actual agreement of purchase and sale. So if you haven't accounted for it in the agreement, I can't help you secure any sort of illegal rights under the contract unless they're actually in the provisions of the agreement. So step one is to make sure your contracts are drafted well, and all of the things that you want, you make sure that they're in the agreement. If the seller tells you something verbally, there's usually a condition, a term in the agreement rather, that we call the entire agreement clause, which basically says that unless it's written in the actual agreement, irrespective of what the negotiation was, we only go by what are the terms and the conditions in the agreement of purchase and sale.
And just to take a step back now, buyer has moved in and the appliances are missing, but they're listed in the agreement.
Appliances are missing.
Appliances are gone. And
okay,
you know, how do you? What's the recourse? How do you proceed? Do they call you? Do you call the other attorney?
So we normally get a call saying, "Hey, the fridge is gone," right? And right away, like as a lawyer, when I sign with my client, we go through the agreement actually to make sure we understand what the clients have bargained for. So if we see, for example, there's no fridge, no stove, no washer, no dryer in the Chattels section of the agreement of purchase and sale, we'll raise a concern right away and say, hey, did you not want these things? Sometimes the buyer says, hey, we bought a new property or we bought a renovated property. The old appliances were garbage. We didn't want them, so we didn't make them a part of the agreement. And then sometimes you get situations where you've actually written them in the agreement and then they're gone. Now, things like fridge and stove and washer dryer, these are common. I've actually experienced situations where the center island in a kitchen is gone because it wasn't included in the agreement of purchase and sale.
Wow.
My goodness.
So you really have to make sure your contracts are drafted well.
But wouldn't a center island in the kitchen be part of the kitchen environment? How does that have to be listed separately?
So arguably, if you can move it around, which more often than not you can with a center island unless it's got a sink in the middle, it's technically a chattel. It's not physically attached to the property.
Unbelievable.
Wow. And how about, minor things that, hey, we did our walkthrough on Thursday, we got our keys on Friday, and now the stove's not working, or, things like that. Like, how do you deal with that during a long weekend?
Asif, that is an excellent question. So when it comes to the walkthrough, the final walkthrough, there's a tendency in the industry when we draft agreements, we write in that the buyer has the right to inspect the property 2 further times prior to closing, right? And more often than not, the listing salesperson or broker goes out, strikes that out, and changes it so it says a visit. You got 2 final visits before closing. Now, it makes no difference whether it's an inspection or a visit. The frank reality is if you as a buyer are walking into that property, hopefully the week of the closing when the sellers have moved their stuff out, and you're looking for any sort of defect. And what I mean by that is when you agreed to buy the property, it was in a certain shape, and you want to make sure the property is in a similar shape that when you agreed to buy it. So if there's any sort of damages, like let's say they moved and the hardwood is now scratched and those scratches weren't there before, you better hope that your home inspector has a log and photo evidence showing the before and after, and you may be able to take legal recourse.
Now, what other issues have to be listed in that agreement post-closing? Because, again, things could change. And how long do I have post-closing to make those complaints and identify those deficiencies?
Again, you got to look at the contract. So the way it works, and I don't want to get overly technical, but the whole concept is that once the deal closes, the transaction comes to an end. This is called the principle of merger. So any sort of representation and warranty that would have been in the agreement, for example, it'll say seller represents and warrants the chattels and fixtures are going to be in good working order on closing. As soon as the deed is registered and the transaction closes, if the fridge stops working 1 minute after closing, it's no longer the seller's problem, right? And so you want to put in a provision that says this warranty shall survive and not merge upon completion of the transaction. So there's specific language you need to reserve in your agreement. And again, as a registrant, if I'm the buyer, salesperson, or broker, I'm going to make sure it says that the warranty survives and does not merge. Whereas if I'm the seller side, I'm going to cross out that last sentence because the last thing I want is the buyer going in, putting in dishwasher soap into the laundry machine and saying, hey, the laundry machine doesn't work anymore. So you have to account for these things. And going back to Asif's point, you want to make sure that before the closing you've gone in, check the appliances and make sure they're working. Now here's the funny part. A lot of people will call me and say, hey, Ricky, the fridge and stove aren't working. We don't want to close anymore. Unless it's a significant and serious issue going to the heart of the contract or heart of title, more often than not, you're not able to say, I'm not closing the deal. Because if you don't close the deal, you're screwed. So you have to be very careful with the advice that you obtain with your attorney. And you should, get advice from your realtor, but make sure you get qualified legal advice and not just listen to the realtor. Because more often than not, they don't understand the nuances. So if a fridge isn't working before closing, I'll get a call from the buyer saying the fridge isn't working, a similar replacement, because you bargain for a used fridge, you're not going to get a brand new one. So a similar replacement is going to cost me $250. Can we do something about it? Now, what we can do is we can suggest a holdback. We can tell the seller's lawyer, this is an issue we found. We want you to set aside $250 until we can either replace or repair or whatever it is, this item. Now, the seller's lawyer, more often than not, will come back and say, hey, it's not in the agreement, so we don't agree to the holdback. And in that situation, I'll go to the buyer and say that, look, your contract doesn't make mention of a holdback, and we can't pull off miracles now because of that.
And that's something that we hear all the time where the buyer is saying, oh, yeah, well, I need this money held back, and the lawyer will write to the other lawyer and say, well, we want a $5,000 holdback until this or this is done. But you're right, that's not part of the contract, so there's no legal right for the other lawyer to be requesting the holdback or expecting a holdback.
That's right. So again, it all goes back to the contract. Sometimes clients will comply. If we say this is what the other party's requesting, are we able to accommodate? Clients will usually accommodate, but sometimes clients that are more sophisticated will say no. And quite frankly, if the contracts are written a certain way, we know more often than not a buyer, if there's a broken fridge, they're not going to go to small claims court for $250. The cost-benefit analysis, it just doesn't make any sense in pursuing an action like that after the fact. So some people play the odds, and we've seen transactions from, perspectives where both parties are very accommodating, they like each other, want to make sure everything is in, ship shape with the relationship. And then we've seen situations where more sophisticated parties come in and say, hey, I don't care. You do what you want. Sue me afterwards. You don't close, I'm going to relist the property right away.
Wow, so it sounds like good faith goes out the window.
No, good faith is always implied. But again, to secure legal recourse, Tina and Asif, it's just, when you got to go through the court system, sometimes a simple letter from a lawyer is good enough. But if the other party refuses, you're in court, small claims court or superior court, depending on the size.
How did the buyer and seller's lawyers come together and find that happy middle ground?
It's all about negotiation. At the end of the day, you want a lawyer that not only, understands the contract, but also has experience in dealing with these sorts of matters, and they come with time. They come with a number of transactions that you over the course of years, do complete. And based on that, sometimes you deal with a lawyer who may not understand it as well. And we work together because as a lawyer, I know I'm going to work with the lawyer that I'm working with on this particular file again. So we don't try to burn bridges. And a lot of lawyers get emotionally invested in transactions, but that's not my job. My job is to give legal advice, keep it professional, and make things happen in the best interest of the client.
That's great advice, Ricky. And again, we thank you for joining us. What's the best way for people to contact you if they need more clarification on this?
Give me a call anytime, 416-731-8478.
Happy Canada Day weekend, Ricky.
You guys as well.
When we come back, we get to your real estate questions and this week's hot listing. And just a reminder, if you missed any part of our show, go to 1059theregion.com. Stay with us.